Hi, and welcome to Bar Talk. Thank you so much for joining us. We have a great show for you tonight. Our first topic is, do we have to put a ring on it? Are there sometimes advantages to not getting married? Our second topic is undue influence in estate planning and probate law. What is it, and what is the legal standard? Our third topic is, the police took my stuff, how do I get it back? Civil asset forfeitures. So I'm very interested in this topic. Can it sometimes be advantageous to not get married?
I think it's interesting that that's the spin you put on it, because my recommendation is, if you are not married and you are cohabitating, that you should be very, very cautious about the choices that you make together as a couple. As some of you might know,
if you're cohabitating and you're not married, you said.
Correct, because a lot of people may not realize that in the last 20 years, the number of couples that are cohabitating without making it legal has actually doubled in our nation.
Yeah, I could see that.
So this affects a lot of people, and you might also have situations where people are just coming out of a divorce, they're getting serious.
But aren't there advantages to getting married if you're in a very serious relationship and you're living together?
I think it's important to know what the rights and responsibilities are. So if you cohabitate, you might be mingling assets, you might be generating debt together, and yet you may not have the protection of the law should the relationship suddenly come to an end. As we know, these things happen.
Right, and not only if you're at the level of seriousness where you are cohabitating and it's for a longer period of time, now this relationship may be the type of relationship where you have a legal protection in terms of your fiduciary. You know, from my standpoint, if something happens to you and you go to the hospital and somebody needs to make a decision and you don't have your powers of attorney in place, they're going to look to your next of kin for that. You know, they're going to look to the Healthcare Surrogate Act, and that person that you're living with might be the person who knows everything that you want to have done. It's kind of the classic Terry Schiavo case.
I think that as far as healthcare planning, a lot of people don't realize to the extent that their domestic partner would be excluded.
Yeah, that's what I mean. Like you may really want that person to be able to make those decisions, and they're not going to be able to.
You would have to do that as a separate legal act.
You'd have to create your own power of attorney.
You're raising a really important point. There might be a number of documents that you're going to want to have in place to protect your legal rights. One of them could be a power of attorney for healthcare or property. Another thing that family lawyers are now suggesting to clients that are in this position is to create something called a cohabitation agreement.
Yeah, I've heard that.
And what this will do is just lay out your expectations with regards to finances, with regards to debt, with regards to property, so that there is something in place when the relationship ends. We don't want one partner having all of the benefits of the relationship and someone being really financially screwed over.
So it's like a contract where you can, I mean, is it like a prenup, but it's for a boyfriend and a girlfriend?
Exactly. That's probably the best way to look at it. It's a contract. It's an agreement. You're laying out what your expectations are, regardless of the genders, regardless of the level of commitment in the relationship. If you're living together and you are perhaps putting money towards a common purpose, maybe you are putting money in someone else's mortgage.
And it seems like some of these issues would be ongoing, because as the relationship gets more serious, you know, like you're saying, maybe then you buy a dog, or maybe then you buy a car.
Well, I think a lot of people assume, I think, that if it's the married people who have to worry about things being commingled, and married people who have to worry about their finances affecting each other. I think a lot of people think that if they're not married, their finances won't affect each other.
And that's simply not true. I would say the most common scenario I see are partners that have lived together. Perhaps one partner is the breadwinner. I'll just say he goes out and he makes all the money, and this woman is supported by him, and yet perhaps she's contributing. Maybe she's helping him grow his business. Maybe she is helping him pay his monthly mortgage, and yet not realizing that if the relationship were to end,
she doesn't have any rights.
She gets nothing.
Yeah. Whereas if they were married,
correct,
there would be a statutory
well,
provision.
if they're married, it would be a partnership.
Yeah, that's what I mean. She has protection within the law.
Exactly. And we look at those contributions, and you can be reimbursed for them. Or we can at least try to, when we divide the assets, make sure that you are being compensated in some way for what you've contributed to the partnership.
So to what extent does the law honor these cohabitation agreements? I mean, what if they're what if they're grossly unfair? Like, oh, you know.
Well, I mean, I would think it would be
this
just
is
like
why
contract
you get
law.
a lawyer. Don't do it on your own.
But I would think it's like the same standard as under contract
Any
review.
other contract.
Yeah.
Exactly. And when you meet with an attorney, they will certainly advise you in terms of making sure that they're notarized, making sure that you have witnesses, making sure that, you know, prior to doing this, you are able to make a declaration that you are of sound mind and you are entering into this agreement of your own free will.
Well, this is very revealing and informative. So you might want to get more information about this if this is something that pertains to you. So we're going to take a short break and we'll be right back.
Packers. Vikings. Packers. Viking. Vikings.
Red state, blue state, vegan,
Carnivore.
We come from different places.
Uptown.
downtown,
Optimist.
We come to different conclusions.
Half empty.
half full.
But when we live united, we create real, lasting change in the building blocks of life. The education, income, and health of our communities,
Live
our families,
united.
even the person next to us.
Live united.
Real change won't happen without you. So give, advocate, volunteer, live united. Sign up at liveunited.org.
I wouldn't have been at this ceremony if I hadn't been at this ceremony first. Unfortunately, nearly 30% of U.S. high school students aren't making it to graduation. And every one of us, every parent, every friend, and neighbor, has the responsibility to provide the support and encouragement they need to make it through. Because we all need to see a lot more of these pictures.
Welcome back. Our next topic is undue influence.
I want to talk about that.
What is undue influence? I think a lot of our listeners don't know what that means.
Well, the idea behind undue influence is generally when you have someone who makes their estate plan and then beneficiaries disagree about whether that was really the person's intent after they pass away. Mm-hmm. And then the claim gets asserted that my mom or my dad or my grandma or whatever was, coerced, influenced. That's the idea of undue influence.
And actually,
there was pressure. That person was pressured. They would have never done that
I think that comes up a lot.
It does. I mean, it comes up in almost
But wait a
every
minute, wouldn't that
contested
be
case.
almost impossible to prove? How do you prove that there was undue influence?
It is hard to prove. And it should be, because the idea behind your laws of testacy, and estate distribution, the idea behind those laws is that it seeks to really preserve your right to make any choice you want with your assets up to your last dying breath. I mean, if you, in sound mind, in the last hours of your life, decide that you want to change the disposition of your plan, you should have that right to do so. It's just an inherent right. And so these laws are set up to really respect that, to try and carry out your wishes. And so because of that, it's really hard to prove undue influence because the standard is very high, the burden of proof and to reach the standard. But it can be done. I mean, they've developed a way through case law and looking at different types of evidence to kind of give some kind of structure to follow when you look at an undue influence case. And I'll just kind of run through, the elements. First of all, you have to have a person who is subject to being influenced. I mean, that can be somebody, who is of advanced age, might be more subject to being influenced than someone who isn't. It doesn't mean that just because someone is old or elderly that they are automatically, but it's certainly a factor to look at, You have to have, as a second element, the disposition to exert undue influence. So there has to be a kind of a bad actor. There has to be someone who has a motivation, a reason.
Sounds like this is when we point fingers at our siblings.
Yeah, you have to have somebody who's in that position.
But it wouldn't even necessarily be one of the children, right? And in
No,
fact,
it
it
can be a
probably often is a
caretaker.
caretaker.
Yeah, I mean,
yes.
that's a very common scenario.
Yes.
Now,
Or how about the new girlfriend who came into
yeah,
Dad's
that's
life
another,
2 seconds
definitely
ago?
another example. A third element is that there has to be the opportunity to do it. You know, there has to be evidence of time and place where this has occurred.
So does that mean an act, like an act of undue influence? Or
well,
what does
it's
that
going to
mean?
be very important that one act is not likely to, you know, tip the scale that far. You know, there has to be opportunities. Even though it says there has to be an opportunity in the law, that's the element in opportunity. But that really means that you have to be able to show that there was enough opportunities to exert this influence. You know, it's highly unlikely that one singular act is going to overcome it. But not to say that, you know, I mean, any circumstance can be kind of drawn up. You know, you can think of a circumstance probably where one act would suffice, but there has to at least be an opportunity to exert that influence. And then, of course, the last element is that you have to have a result. You have to have that result that indicates there was undue influence.
So maybe that there was a change suddenly in
a
a
will.
Yeah, you know, you know, you have to put all these pieces together, and those are your elements, and you're trying to build a case under each of those elements. So things to look at would be like, did the testator or the person, you know, who made the plan, was that person lacking any intellectual capacity? You know, what was their medical history at the time? What was did they have a debility? Meaning, were they frail? Were they weakened? What was their age, and what was their mental capacity at that age? You know.
So let me guess, is this something that people can do pro se, or do you need an attorney for this? My thoughts are, you definitely need an attorney.
Well, I mean, you have every right to bring a case pro se, just like in any proceeding. But these elements are difficult to prove.
I would agree. I mean, I think they're difficult to understand. The opportunity element.
So the advantage of having a lawyer is someone who has seen or participated in these types of cases, or has a lot of experience in researching these types of cases even, will know what works and what doesn't work, you know, in your state. They have a body of law where they can look at these types of facts. Overcame the burden, these types of facts didn't.
Well, there you have it. Those are the elements. So if you're interested in this, if this pertains to your life, you want to check out more information on it, we'll take a short break and be right back.
I wouldn't have been at this ceremony if I hadn't been at this ceremony first. Unfortunately, nearly 30% of U.S. high school students aren't making it to graduation, and every one of us, every parent, every friend, and neighbor has the responsibility to provide the support and encouragement they need to make it through. Because we all need to see a lot more of these pictures.
Packers. Viking. Packers. Viking. Viking.
Red state, blue state, vegan.
Carnivore.
We come from different places.
Uptown, downtown,
Optimist.
We come to different conclusions.
Half empty.
half full.
But when we live united, we create real, lasting change in the building blocks of life. The education, income, and health of our communities,
Live
our families,
united.
even the person next to us.
Live united.
Real change won't happen without you. So give, advocate, volunteer, live united. Sign up at liveunited.org.
Welcome back. Our next topic is civil asset forfeitures, which have received a lot of media attention lately because there was a very controversial piece in the Chicago Reader about just how...
What is a civil asset forfeiture?
Basically, it's in the course of any prosecution of any crime, the state has the right to basically petition to take
Take your stuff.
your stuff. Anything
Because
that was
you committed
involved.
a crime.
Well, they have to show that it was connected, basically connected to the crime.
Is it for the purpose of evidence?
No, it's separate from that. I mean,
Why do they want it?
because they sell it and then they take the money.
Hey, wait a minute. That sounds odd to me.
Wait a minute.
Oh, yeah.
They take the property connected to the crime.
Yes.
Let's say it's a computer.
Yeah. It's a
Or
great
a-
example. Or a brand new laptop, like a brand new
But wait, what if I'm
iMac.
married and my spouse commits a crime and then this asset is forfeited?
Well, that's usually what these civil hearings are about, these civil trials, basically.
And they want to take it just for the purpose of selling it?
Oh yeah.
And
Basically, the idea
you don't have a say in keeping your stuff?
I think the purpose behind this law is to say, well, if this was used in furtherance of a crime, then it shouldn't be the taxpayer's burden to fund the offices that that work so hard to prosecute these crimes. The police, the state's attorney's office. It's basically split three ways between the Chicago Police Department, the state's attorney's office, and the Illinois State Police, and they divide up the money.
How, if the criminal is the sole owner of the property, that maybe that would make sense.
No,
But
So
what
the idea is to generate income to pay for the prosecution of the crime.
Right.
But does this happen after the conviction?
It can. Well, it frequently does. So here's the thing.
Wait, but does it happen before the conviction?
Sometimes. No. Well, so basically the judge has the option to delay the case until after the conviction, until after the disposition, the final disposition of the case.
For the civil civil assets
Right.
forfeiture.
But let's say so in the case that was basically reported in the Chicago Reader, it was basically like an elderly kind of grandmother whose, I think, son or grandson took her car and
Committed a crime.
Didn't have permission to take the car.
Right now she's
And
out
they
of
wanted to take the car?
Oh, they took the car.
They took the car?
They took the
The
car.
car is
well,
gone.
So the reader,
Was
for
it her?
sensational purposes, wanted to use a case that was with bad facts, right? So this was a woman who appeared pro se. Judge didn't know reporter was in the courtroom. She went up to the bench. She had appeared 9 times before, kept getting continuances.
She's trying to get her car back.
Trying to get her car back.
The
and
little old lady?
The judge looks at her and says, if I give it back to you, it's going to go right back into selling drugs.
What?
Yeah.
This car was in this little old lady's name.
Only her name, not her son's name.
And her son took her car, committed a crime.
So in
and they
essence-
took her
drugs.
car.
In
And
essence,
she had no
They
defense.
sold her car and divided the money.
She shouldn't have
Like
let
they always
the
do.
grandson take the car, right?
He didn't
I mean,
ask.
that's the
He didn't
lesson.
ask. He took the keys.
He didn't
without
ask.
Well, but then you shouldn't have let him in your house.
What?
I'm just saying.
Well,
You gotta protect your stuff.
it's
How's she gonna
interesting.
get-
I mean,
how is she gonna get to the
judge
grocery
gets
store?
to
What is the
decide.
defense for this lady?
Well, I think if she had hired a lawyer,
Yes.
first of all, the lawyer would have filed a hardship motion. So I used to actually
Right.
appear on behalf of the state and do this. So
Let's hear this. How could this lady have kept her
if she had
car?
hired a lawyer, actually, a good lawyer would have, first of all, filed a hardship petition, say she needs the car, she needs to get it back, ASAP, no continuances, and they would do a trial really relatively quickly. If not that same day, then the next one continuance. And in that case, they would have to show that the car was connected. I mean, that's easy enough. It sounds like in this case, the reader doesn't go into a lot of details, but in this case, it was connected.
Okay.
But then they would also have to show that basically it was that somehow she was involved in that decision. And in this case, I think that with a good lawyer, the lawyer could show that she was as much a victim as the rest of us in this crime.
And the lawyer who, would act on her behalf would get a trial, and that's what she
Would get a hearing date, yeah.
But why couldn't she get her own trial?
Well, that's
Is there
interesting,
a,
isn't it?
Is there a? Do you have to have a certain element to get to a trial?
So,
Like where you said hardship.
oh well, she would have to show that she needs the car. I think that would be easy in this case because
you
she
always
she
have to-
relied on it for everything. She had a
Right.
daughter with MS or a granddaughter with MS that she would take to the doctor, and she couldn't do it. They were,
Okay.
it forced them to take buses and
This
taxis.
is getting worse by the minute.
Yes, yes.
But
that's why this.
if we
this got
apply
so
it
much
just in
attention.
general, when you're in this kind of case, when you want a trial, do you have to say, I have a hardship?
Right.
You have to say, I
Well,
have a, you can, you
She
have to
didn't
show.
know. She didn't know about that.
But forget
at
about
all.
her. In general, when
Yeah.
you want
Well,
a trial.
if you want the state not to succeed in continuing it until the end of the case, then yes, you have to make a hardship motion. You have to say,
That's how you get a trial.
Yes.
There's no other way to get a trial?
oh no, you'd still get one, but the state will move to continue.
Yeah.
Your Honor, this case is ongoing.
Yeah.
We need to continue until the final disposition of the case. Because ideally, then that would give them more information. I mean, more information generally is better than less. And the judge would probably say yes. I'm sure there are some judges who would say, well, how reliant are you on this car? If they see someone in a wheelchair, if they see someone with a
Yeah.
walker. But this judge didn't.
Okay, quick question though. What if a firearm is used in the commission of a crime?
Same
They get
situation.
sold as well?
Oh, yes, they do.
I had no idea.
Yes.
I'm still stuck on the process of saving yourself.
Dana, we're not going to solve all of your questions and all of the world's problems today. Just
Well, it's
FYI.
amazing. Well, this is truly one of those scenarios where you should, if it's a very valuable asset, obviously you have to weigh the cost of the lawyer, right? But if it's a very valuable asset, you can really benefit from having a lawyer because, it's the state's attorney's office. It's money that goes directly to the state's attorney, so they have a vested interest in getting this money. So I hope that was informative. We're going to take another short break, and we'll be right back.
I wouldn't have been at this ceremony if I hadn't been at this ceremony first. Unfortunately, nearly 30% of U.S. high school students aren't making it to graduation, and every one of us, every parent, every friend, and neighbor, has the responsibility to provide the support and encouragement they need to make it through. Because we all need to see a lot more of these pictures.
Packers. Viking. Packers. Viking. Viking.
Red state, blue state, vegan.
Carnivore.
We come from different places.
Uptown.
Downtown.
Optimist.
We come to different conclusions.
Half empty.
Half full.
But when we live united, we create real, lasting change in the building blocks of life. The education, income, and health of our communities,
Live
our families,
united.
even the person next to us.
Live united.
Real change won't happen without you. So give, advocate, volunteer, live united. Sign up at liveunited.org.
Hi, and welcome back. Next up is our hot topic, which today is when can an attorney withdraw from a case? Are there rules surrounding that, and what are they? So, do you have any thoughts on what would be of concern to our audience as far as when attorneys can withdraw?
Well, I think the most common scenario is an attorney desires to withdraw when they can no longer communicate with their client.
Mm-hmm.
So that could be the client's MIA, right?
Right.
The client is not cooperating.
Well, MIA, I mean, you have to withdraw. I think the rules require you to withdraw. If the client is not communicating with you, I believe you have to. You have no choice.
Well, you can't adequately represent them, right?
Right.
And represent their interests if you are not in communication with them. I think a common concern, though, for clients is what if the communication is just not going well, right?
Right.
What if you're not seeing eye to eye? What if you want to fire your attorney, but you're not really sure if you're allowed to? I think there's a lot of confusion out there.
There shouldn't be any confusion about whether you want to fire your attorney. You can always do that, right?
I certainly have had clients call me stating that they are unpleased with their current representation and they don't know what to do.
So let's get it out there. If you don't like your attorney, you can fire them at any stage in the game.
Yeah,
you know,
we're giving
that
person away for free.
That person works for you. You're
for any reason.
yeah,
or
absolutely.
No reason.
I mean, you hired that person.
You don't
Just
need
like
a
if you
reason.
hired somebody to do work on your house and you don't like the way they're working, cut them off. And that you have that right. You are the client. You are directing the show.
Yeah.
But I think it's a little bit different when it's the flip side. You know,
Right.
when it's the attorney who wants to withdraw. And now the client may or may not know that the
Right.
attorney wants to withdraw.
So I would like to see how this affects different disciplines because
Well, I would certainly say when it comes to a divorce, you should not be firing your attorney without knowing what the consequences are based on where you are in the process.
Yeah,
so if we
I can
are
see that.
2 minutes before a trial, you certainly have the right to fire your attorney, by all means. But do know that you might be representing yourself at that trial. The judge does not have to give you adequate time to obtain new counsel if you are so close to the resolution of the case.
Wow.
Right.
So do judges typically force litigants in family law cases to go pro se?
Well, they always like to give them the opportunity to obtain new counsel, but the question is how much time? At the beginning of the case, you could be granted 2, 3 continuances
Sure.
and state you're trying to obtain new counsel. But towards the end of the case, I think it goes to your point of when can an attorney withdraw? If you're a divorce lawyer and it's right before trial, the judge does not have to let you go.
Well, and I think that's important for people to understand, is that if you have an attorney that's trying to leave you, there are some responsibilities on attorneys, and the judges will see to it that clients are not left high and dry. So attorneys are asking to withdraw, and so that's when all these factors come into play. And people should know that the goal here is not to leave clients, you know, completely
Yes.
in the dark without
Yes.
any help.
Or in a worse position that they would have been otherwise, and really not adequately represented. So what if a client doesn't feel like they know what's going on in their case? Granted, this should never be the situation, but sometimes it is.
Right. And do you think, I mean, let's say an attorney wants to withdraw. Do you think a client can say, I don't want him to withdraw?
Oh, absolutely. In criminal cases, it actually happens, I think, more than in any other field. It happens in any other area
Where
of
the
law.
attorney wants to withdraw and the client says, I
If
don't want him
it's close enough to trial, the judge will say, I'm sorry, I'm not going to let you withdraw. I want this trial to happen on this date, and it's going to happen on this date. And
Although, wouldn't that be
one.
grounds for an appeal in terms of stating that maybe your attorney wasn't committed and maybe they weren't
Well,
competent?
that's on the attorney. That's on the attorney.
Yeah,
truly,
and the
because-
attorney is still bound. You're bound to represent your
rules-
client with zealously.
Yes,
I don't
exactly.
know how zealous it's going to be if you're trying to leave.
Well, that
just
would be a
like saying-
concern, I would think, but but it happens all the time.
But that's your duty. I mean, as that person's, you know.
That's right. So that's the basics on this topic. I hope that you can join us again for Bar Talk. And please, if you enjoyed the show, visit us on Facebook and Twitter. And hope to see you again next time.